It's officially 2025, and the road to Sean Combs' criminal trial has begun. But it seems both the prosecution and the defense can't seem to agree on a number of key deadlines in this case for when information will be disclosed and arguments will be presented. With all eyes set on a May 5th, 2025 trial, will that still hold? We're going to break down one of the latest filings from both sides in this high-profile case. I actually think one of the more controversial elements of Sean Combs' prosecution is not even the allegations of sex trafficking or racketeering or freak-offs or baby oil or sex workers. I mean, it's all quite controversial. I still think, though, one of the biggest issues, one of the most controversial things we've been talking about in the legal community especially, is the trial date. I mean, for a guy who was arrested in September to go to trial on these federal charges on May 5th, 2025, which is right around the corner, just over 7 months after his arrest, given the mountain of evidence in this case, how complex a racketeering, conspiracy, criminal enterprise case can be, that is so soon. I've said that for a while. How do you go to trial so soon? Are both sides really ready? And look, that date was agreed upon, and I think that an argument could be made. It was pushed by Sean Combs' side while he was still trying to fight bail, even though we know he lost every time he tried to petition for pretrial release. So there seems to be an argument that he wants to hold the prosecution's feet to the fire, right? After all, it's their burden. They have to prove this case. Get this case over with, as opposed to what would be the alternative? Languishing in a detention center for years as he awaits a trial? Because he's currently locked up at the Metropolitan Detention Center in Brooklyn. That is notorious for its violence, its horrid conditions. So I get it. The argument could be, let's get this trial over and done with. We think we can win. That's it. Let's put it in the past. But I've also wondered, would that trial date stick with so much going on? Well, I tell you that because the trial date has come into focus once again in a new filing from both the prosecution and the defense. And that is what we're going to break down for you right now, this letter. This letter that was addressed to Judge Arun Subramanian of the Southern District of New York, the judge overseeing this criminal case. And in this joint letter submitted by both parties, it discusses the pretrial schedule, so everything leading up to the trial. And by the way, you might be saying this seems boring. No. The reason this is so important, the reason these dates are so important is, aside from the fact that it kind of gives us a sense of the strategy of both the prosecution and the defense, is because those dates are so important because if those dates hold, whichever side we're going to be going through, if the judge decides with the prosecution or the defense, or there's times they consented to a date, that is giving us a window of when and if we can learn some new key details about this prosecution and defense. So much of this case has been wrapped up in mystery in terms of the actual events, the witnesses, the victims, the defenses. So if these dates stick, we now have a timeline of when things might be presented and what things might be presented. This is important. So now the question is, what is this pretrial schedule? Well, as the lawyers lay out in this joint letter to the court, they write, the court set the following pretrial motion schedule. Motions due on February 17th, 2025, oppositions due on March 3rd, 2025, and replies due on March 10th, 2025. Again, this is all leading up to the May 5th, 2025 trial. Now, the prosecution and the defense have two different perspectives on this schedule, and I'm going to start with the prosecution. They write, given the May 5th, 2025 trial date in this case, the government respectfully submits that the current pretrial motion schedule, in which the pretrial motions would be fully briefed less than 2 months prior to trial, will not permit the parties to raise and the court to resolve pretrial issues sufficiently in advance of the May 5th, 2025 trial. While the defendant is fully entitled to request a speedy trial, that does not mean that he's entitled to demand disclosure deadlines appropriate in cases with significantly longer timelines. Accordingly, the government objects to any schedule, including that proposed by the defendant, requiring the government to make trial disclosures before the filing and or resolution of pretrial motions which may shape or affect those disclosures, including by affecting the scope of the charges or the evidence the government is permitted to rely upon in its case in chief. Okay, so a lot of legalese. What does all that mean? Well, basically the prosecution is saying, look, There are a lot of filings and issues that need to be resolved before trial, which, by the way, I will get into. But essentially, the government is saying on the current schedule, there's not enough time to sort all this out. And even though Sean Combs has a right to a speedy trial that's enshrined in the Sixth Amendment, protects against undue or unreasonable delays in criminal cases, even though Combs has that right, the prosecution argues it doesn't mean we have to disclose certain aspects of this case prematurely. We shouldn't have to turn over things earlier than we would in other federal cases, and it's too premature for us to disclose certain things before we even resolve some important pretrial issues. Because then, if we did that, the disclosures wouldn't even make sense, or maybe they don't apply anymore. Now, before I even get into what all those issues and those disclosures are, the prosecution proposed a revised timetable. So they want to move up the current pretrial motion schedule by about 2 weeks. In other words, January 31st, 2025, pretrial motions, February 14th, 2025 for oppositions, and February 21st, 2025 for replies. The defense has taken a different position. They want the current schedule as it's laid out, and they want the government to disclose certain things basically ASAP, basically now. They write, the defense objects to a modification of the existing pretrial schedule, which has been set for months. Defense counsel have planned around the existing schedule and are not in a position to file pretrial motions in just 4 weeks, and only 1 month after the close of discovery, which included thousands of pages of search warrant affidavits. Then they say, prosecution, don't worry about disclosing things too early to us. They say, look, we're going to move to dismiss these charges. We're going to move to suppress evidence from coming into trial because we say the evidence was obtained unlawfully by authorities. And even if we're successful and the scope of the criminal case is narrowed, the defense says this would simply make any trial disclosures over-inclusive. There's no danger there. The defense argues the risk that Mr. Combs will be deprived of a fair trial is far greater than the de minimis risk of over-inclusive disclosures on the part of the government. Meaning, Combs has a right to have the government disclose everything now. If it's too much, if it's over-inclusive, because, the case is whittled down later on, so be it. There's not much danger there as opposed to he has a right to know everything at this point. And they also say, you know what? We may not even file any pretrial motions in the end, in which case these disclosures from the prosecution, they shouldn't really depend on this motion schedule at all. So now I bet you're wondering, well, what has to be disclosed? What are we even talking about? What has to be exchanged here? Well, that's what I'm going to get into next. So the letter talks about that. So first, we have something called an enterprise letter that the government proposes filing. Now, an enterprise letter, quote, will set out the specific acts and conduct underlying the racketeering conspiracy charged in the indictment. So what we're talking about is providing Combs and his lawyers more information, more particular notice of the specific objects of the charged racketeering conspiracy, including, to the extent possible, the dates, times, places, and participants for each racketeering act. And by the way, that is something that Combs' attorneys have been asking for quite some time. They want to know more specifics. They want to know how they can properly defend Sean Combs. They need to know the specifics of these different acts. And the racketeering charge in the indictment, it has a number of underlying acts: kidnapping, forced labor, sex trafficking, bribery. The idea again is there was a criminal enterprise controlled by Sean Combs that engaged in all sorts of illicit activity, and there was a criminal agreement amongst Combs and others to further this enterprise, to violate the racketeering laws. But so far, the government really hasn't explained each instance. Who are the alleged victims? Who are the witnesses? What's the description of these events? We don't know. That hasn't been laid out. So the government is saying, we will produce that to you, but we are planning on producing that on March 7th, 2025. So that's 8 weeks before trial. And that will include the court's rulings on pretrial motions, like what evidence will come in. So basically, the prosecution is saying, we really can't produce this enterprise letter and be accurate about the case until we know which way the court is going to rule on key pieces of evidence. The prosecution says defense counsel's proposal that the enterprise letter be filed prior to pretrial motions is contrary to the practice in this district and inefficient, given that pretrial motions could impact the substance of the letter. So again, they're saying them laying out their entire case and what they have, it's too premature. The court has to work out other issues before we can submit the letter. And the government argues that Combs isn't playing fair. Quote, the defendant was arrested in September 2024, and the trial date was set at the defendant's insistence for May 5th, 2025, a span of fewer than 8 months. The defendant is trying to have his cake and eat it too here by insisting on a speedy trial, but also insisting on deadlines in cases with much longer timelines. And by the way, speaking of the defense, here is their position on the Enterprise letter. They write, quote, Mr. Combs is at a significant disadvantage. Defense counsel still do not understand the contours of the government's allegations, including who the government even considers a victim, and have repeatedly asked for assistance from the government. Unless and until the government is required to make trial disclosures, the defense will remain ignorant of the evidence it is required to meet. The result will be a fundamentally flawed trial. Accordingly, Mr. Combs proposes that the government file its Enterprise letter by February 1st, 2025. So that is less than a month away. That's just a few weeks away. So that is one disclosure issue in this letter. Also in the letter, we move on to notices regarding who will be called as expert witnesses and rebuttal expert witnesses. So here, the prosecution is proposing that all parties, the prosecution and the defense, provide notice of their experts about 8 weeks before trial, March 7th, 2025. And rebuttal experts, if there are any, 2 weeks later, by March 21st. So that is 6 weeks before trial. And the reason that you need to provide notice to the other side of who you're planning to call is because opposing sides need time to vet the reliability and the relevance of expert witnesses. In the law, we call that the Daubert standing or briefing on Daubert. Now, the prosecution says here's the problem. Combs' lawyers have indicated they are not going to provide their notice of who their experts are until the prosecution first provides their experts. And the prosecution says that's inefficient. It won't provide them enough time to file challenges, and that is inconsistent with how things are done here. And speaking of the defense, they say, yeah, prosecution, you know what? You should present notice of your experts by March 7th, 2025. Then we'll provide notice of our experts for the first time on March 21st, 2025. And then government, you can provide your rebuttal experts on March 28th. And despite the prosecution's argument, the defense is saying this is consistent with how things are done and what the federal rules of criminal procedure say. And there's a special rule about that. Perhaps both sides will debate on if the defense has to disclose their experts, only if the defense first requests the same from the government. It gets a little complicated, but it's going to be a back and forth about when exactly the defense has to submit their experts to the prosecution because, again, both sides need time to prepare challenges to those experts. From there, we have something called 404B 413 notice. So this is about evidence of other crimes or acts or wrongs that were committed by Sean Combs that may be used to show things like motive or lack of accident or that there was a plan. And also, this concerns evidence of other sexual assaults. So basically what we're talking about is what the government plans to introduce and for what purpose and how they will introduce it. And the prosecution plans to provide notice of this by March 7th. Combs' team says the government should have to disclose this by February 1st. Okay, so you get back and forth about what the date will be. From there, we have something called motions in limine. So motions in limine, and for anybody who's been following our trials might know what these are motions to exclude evidence or arguments from coming into trial. The jury will never hear about this. For example, something might be too prejudicial, or maybe it's not relevant, or maybe it was obtained through illegal means and can't come in and needs to be suppressed. So the prosecution is asking for all parties to file their motions by March 21st, oppositions to those motions by April 4th. The defense has put forward a different timetable. They are asking for both parties to file their motions by April 1st and oppositions by April 11th. They say unless the government makes disclosures earlier, we just can't be prepared to file motions in limine by their timeline. In other words, how can we know exactly what needs to be excluded or what we want to be excluded from trial unless the government provides us some disclosures about their case? And then from there, we move on to another section of the letter discussing 3500 material. So that's about statements and reports of government witnesses, including their attorneys. The government wants to produce all that by March 21st under an attorney eyes only designation, probably to make sure that no information about the witnesses is leaked before the trial, and also only in an attorney's possession designation so Combs can review that material in April. And the government highlights that there is a need for this because of allegations of witness tampering and obstruction on the part of Combs. We've talked about these allegations before, that Combs allegedly, including while locked up at the MDC, had tried to reach out to witnesses and victims in this case, even by using intermediaries. The defense says, no. We want the government to disclose this 3500 material about the witnesses by March 1st. And they argue otherwise, the government could potentially be withholding exculpatory information from the defense until March 21st. That's not fair. When we're talking about exculpatory evidence, this is favorable evidence to the defense. And by the way, more specifically, in the letter, this is what the defense argues regarding victim 1 in this case, who we believe is Cassandra Ventura, Combs' ex-girlfriend. She filed that initial lawsuit against him in 2023. That got the ball rolling on all of the other lawsuits and potentially the criminal charges. So they write in this letter, for instance, the government appears to take the view that information undermining certain claims by victim 1 need not be disclosed promptly because it is merely impeachment rather than exculpatory and therefore should not be disclosed until the 3500 deadline. Basically, the government is saying, look, this evidence doesn't prove Combs didn't commit the crimes that he's charged with, but it's evidence that can be used by the defense when they cross-examine victim 1 when she takes the stand at trial. In other words, there's no reason for us to present this kind of evidence to you earlier than what we're proposing. But the defense writes, this overlooks the fact that evidence that undermines her claims also undermines the government's theory of the case and the criminal allegations, making them affirmatively exculpatory. It also minimizes the time required to make effective use of the withheld information. Of course, regardless of whether information qualifies as exculpatory or impeachment, it must be disclosed in time for its effective use at trial. And the defense continues, moreover, because the government continues to refuse to identify who it views as a victim, also means that the government is also failing to meet its Brady and Giglio obligations with respect to any other alleged victim. Requiring Mr. Combs to follow up on all exculpatory evidence in the 6 weeks before trial is unconstitutionally burdensome. 3500 material should also not be produced with an attorney eyes only designation, particularly if the court adopts the government's proposal to delay disclosure of such material until March 21st, 2025. Defense counsel will need Mr. Combs' assistance to properly review the material and effectively prepare for trial. Now, finally, the parties they agree for once. They agree about the witness and exhibit list. The prosecution proposes submitting that list 3 weeks before trial, April 14th, 2025. They say earlier than that doesn't make sense because those motions in limine excluding evidence or arguments won't have been decided yet, and that will affect who or what the government will present. They say the defense can present its list by April 25th, 2025, so that's 1 week in advance of trial. The defense agrees to both. And then both the prosecution and the defense agree to April 11th as the deadline for the jury questionnaire forms. So those are sent out to prospective jurors across the jurisdiction, starts the whole jury selection process on who will be called into court for further questioning and examination. And also both sides agree to April 25th as the deadline for requests to charge or voir dire. That's the more specific process for selecting the jury, and also proposed verdict forms to be submitted. So in the end, what do you see here? You see a little gamesmanship, you see a little strategy, a little practical difficulties all at play here. Remember, it is the prosecution's burden. The defense arguably wants to trip them up, right? They don't want them to be as prepared as possible, trying to take any advantage they can. So this unidentified Jane Doe has sued both JayZ, Sean Carter, and Sean Diddy Combs. This is out in New York. This is out in New York federal court, to be more specific. And she is claiming that when she was just 13 years old, she was raped by both of these musicians at a Video Music Awards after party back in 2000. And now JayZ, who is adamantly denying the allegations, is not only trying to get the whole case dismissed and thrown out, but he is also asking the court to impose sanctions upon Jane Doe's Texas attorney, Tony Buzbee. Now, this may sound very familiar, by the way, because this has been an ongoing legal war between Buzbee and JayZ and his legal team. Accusations that Buzbee engaged in extortion, that his firm pressured a client to lie, that JayZ's camp has been engaging in intimidation and harassment. JayZ called Tony Buzbee a deplorable human being. He even filed a lawsuit against Tony Buzbee. And by the way, JayZ and his legal team, their position was that Buzbee had extorted the rapper, that Buzbee allegedly threatened JayZ during negotiations that he would go public with these claims. JayZ says these are false claims, but public with these claims unless JayZ agreed to pay what they claim is a, quote, exorbitant sum in private mediation within a 2-week period. JayZ says that when he refused, that is when he was named by Tony Buzbee in the lawsuit. Remember, this lawsuit first came out. It was only identified as unnamed celebrity A, and then in an amended complaint, JayZ was identified as celebrity A. So you're seeing this really bad blood between the different players here. I mean, it got so bad that the judge in this case, Judge Annalisa Torres, actually scolded JayZ's lawyer, Alex Spiro, writing in a recent order, Carter's lawyer's relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast-track the judicial process merely because counsel demands it. Now, despite not allowing JayZ to immediately file for sanctions, Judge Torres did permit JayZ to file the motion that we're about to talk about. And this is big. So this is JayZ's memorandum of law in support of his motion for sanctions and dismissing the complaint. So basically, these are his legal arguments. So the filing begins right on page 1. While the allegations stated in the complaint in this case are gravely serious and injurious to Mr. Carter's hard-won reputation, many of them, on their face, strain the outer bounds of credulity, and none of them appear to have been subjected to even the most rudimentary diligence by the filing attorney who initially signed his name to them and has since declined to withdraw them. Because the federal rules and professional ethics require more of a filing attorney, Mr. Carter now respectfully seeks appropriate sanctions. And by the way, when we're talking about sanctions under Rule 11 of the Federal Rules of Civil Procedure, we're talking about a way to punish attorneys for really bad conduct. Usually it's a monetary punishment. It's rare. It's rare. You don't see this all the time. You have to be talking about really egregious bad behavior. You know, Rule 11, it's about making false representations to the court, filing a lawsuit for an improper purpose, like merely to harass someone, that you're asserting claims or defenses that are not backed up by the facts, the law, the evidence. The bottom line here is that Rule 11 requires attorneys to conduct reasonable inquiries into the facts and into the law before they file. Makes sense, right? Well, Alex Spiro, JayZ's attorney, claims that Tony Buzbee violated Rule 11 by, quote, either knowingly making false allegations about Mr. Carter in the amended complaint, failing to conduct an adequate investigation into the complaint's factual allegations, or at a minimum, failing to withdraw the complaint once it became clear that numerous allegations in the complaint are false and the other allegations are therefore at least highly suspect. So what do they mean by these allegations are false? Well, here is where it gets a little tricky for Jane Doe, because NBC News actually interviewed her, and they looked into this case. They looked into her claims. And here's what the filing says. NBC News journalists determined that a number of allegations were either false or highly doubtful. For example, paragraph 44 of the complaint claims that the party, again, this is the party where she claims she was assaulted, the party occurred at a large white residence with a gated U-shaped driveway that was approximately 20 minutes from the VMAs by car. But photographs show that after the VMAs, Mr. Carter attended a party at Lotus, a nightclub in New York. And by the way, there is a photo included here, provided by Alex Spiro, of JayZ at what appears to be a party with a lot of people. Later on in the memorandum, he writes, other photographs from that evening also show Mr. Combs with his then-girlfriend, the musician and actress Jennifer Lopez, at 2 different establishments, Lotus and Twirl, neither of which was a large residence with a U-shaped driveway. And there is another photo that is included. This time it's of the pair, Jennifer Lopez, Sean Combs, and there is a caption at the bottom that says that they are at a MTV Video Music Awards after party at Twirl on September 7th, 2000. But that is not the only alleged inconsistency. You see, Jane Doe has claimed in her complaint that she was able to escape this situation and run away to a nearby gas station, call her father to pick her up. Well, the filing says, paragraph 60 states that after the alleged assault, plaintiff's father drove to pick her up. But her father has no recollection of doing so, despite the fact that it would have been a 10-hour drive round trip to retrieve his 13-year-old daughter from a random gas station. And yeah, that was included in the NBC report. It was a big part of it because this accuser's father told NBC, quote, "Feel like I would remember that, and I don't. I have a lot going on, but I mean, that's something that would definitely stick in my mind." Now, Spiro continues in this filing saying, paragraph 46 states that plaintiff spoke to celebrities at the alleged party, but when journalists pressed her as to which celebrity she spoke with, she named a person who was in Chicago that evening performing a concert. So Spiro explains a little bit more about this later on in the filing, where he writes, plaintiff also claimed with certainty that she spoke with musician Benji Madden at the alleged party about his tattoo, The Last Supper. She supposedly remembers this interaction with clarity because she has a religious background, so it was something to talk about. But Mr. Madden was not even in the state of New York. His representative told NBC that he did not attend the VMAs and in fact was on tour in the Midwest with his band Good Charlotte. Then, Spiro writes, paragraph 40 states that plaintiff watched the VMAs on a Jumbotron. In fact, photographs from that evening show there was no Jumbotron, as New York City had denied MTV a permit. And included, also by JayZ's legal team, is a screenshot of what appears to be a video, so it's a still shot, from a YouTube video that is titled 2000 MTV VMAs Red Carpet. And it appears that someone is performing on an outdoor stage in New York, but from that pic, yeah, you don't see a Jumbotron. Then, Spiro continues, and the same paragraph says that plaintiff approached limousine drivers at the VMAs. And by the way, the allegation was there is that a limousine driver had taken her to this party. But, Spiro writes, video shows that the limousine area was cordoned off by police and inaccessible to fans. And included is another screenshot of that same video from YouTube of the exterior of the Radio City Music Hall where the VMAs was being held. And you see limousines outside with police appearing to be on each side, and there are barricades. Now, this accuser did concede to NBC that she has, quote, made some mistakes in her retelling of the story, but she stands by her account, saying you should always fight for what happened to you, you should always advocate for yourself and be a voice for yourself, you should never let what somebody else did ruin or run your life. I just hope I can give others the strength to come forward like I came forward. But obviously, JayZ and Spiro disagree, right? And they say in their memorandum, confronted with those glaring red flags, a competent and ethical attorney, again talking about Tony Buzbee, would have not only omitted the many erroneous allegations from the complaint, but also completed a thorough and careful vetting of the core assault allegation before affixing his or her signature to the complaint. Abiding by that ethical duty was especially important here, given the defamatory character of the assault allegation and the near certainty that the complaint would generate massive publicity in light of the identity of the defendant, irreparable reputational harm, and forcing him to explain to his own children that he had been falsely accused of assaulting a child. And conducting a thorough inquiry is particularly critical, whereas here, the plaintiff has no corroborating witness for her account and claims that she did not tell a soul about the incident at any point in the last quarter century, including her father, who supposedly picked her up. Spiro continues that a reporter was able to undercut almost all of the events of plaintiff's narrative just 5 days after the FAC, the First Amended Complaint, was filed only highlights the complete lack of investigation undertaken by her own attorneys. A simple call to her father, a review of publicly available video footage and photos from that night at and after the VMAs, or a review of publicly available property records would have quickly revealed the implausibility of her allegations. But Mr. Buzbee has all but admitted that he declined to undertake such a basic investigation. When confronted by NBC News journalists with a series of false allegations in the complaint, Mr. Buzbee sought to cover for his utter lack of diligence by claiming his client would undergo a polygraph examination, an offer he seems to have abandoned since making it weeks ago. And he passed the buck, stating that another unnamed firm had vetted the allegations and that the Buzbee law firm would, quote, continue to vet claims and collect corroborating data to the extent it exists. So yes, that is true based on the NBC reporting. He said that. And JayZ argues that's not adequate. That is, quote, entirely improper, and that it was Buzbee's job to conduct a factual investigation before he signed and filed this complaint, not afterwards. And JayZ and Alex Spiro double down on this, and they make the argument that if you look at how Tony Buzbee has conducted himself since Combs was arrested and indicted, it shows that Tony Buzbee hasn't been doing his proper due diligence. Why do they say that? Because after that happened, after Sean Combs was arrested and indicted, They say that Busby apparently published a 1-800 hotline number for potential plaintiffs to sue Sean Combs for abuse. And they say just 2 weeks later, he holds this press conference where he claimed that more than 3,000 people had contacted him through the hotline, and that he claimed he was representing 120 plaintiffs who wanted to bring lawsuits against Sean Combs. That is true. He did hold that presser. We covered this on prior sidebars. But they argue, quote, that sequence alone strongly suggests that Mr. Busby's vetting of claims was grossly deficient. Even assuming Mr. Busby set up the hotline on the same day that Mr. Combs' indictment was unsealed, the sheer number of calls that Mr. Busby allegedly received within the 2 weeks between the unsealing and the October 1st press release indicates that Mr. Busby could not possibly have vetted every caller's allegations to the extent necessary to establish the veracity before signing up 120 of them as plaintiffs. But within weeks of his press conference and in an apparent rush to be the first attorney to get claims on file against Mr. Combs, Mr. Busby filed 15 lawsuits on behalf of individuals who contacted him via the hotline in this court alone. So the basic argument was that Busby didn't properly vet these claims, that he appears to not even spoken to the accuser's father, which would have been a simple thing to do. And when he started to see cracks in this case, he should have withdrawn the complaint. And they argue that he is not engaging in his ethical responsibilities. And they even go so far as to suggest that maybe that is why he has not obtained temporary admission to practice law in this court, the Southern District of New York, for this case. Because in the law, we call that pro hoc vice. That's where you're temporarily admitted to try a case in a jurisdiction they are not otherwise admitted to. We talked about this previously on another episode of Sidebar because he was defending himself, Tony Busby, in a prior filing. And he was basically saying, look, I'm not trying to avoid being sanctioned. I'm not trying to avoid the court having authority over me to avoid being sanctioned. And I am a member of the State Bar of New York and am admitted to the Eastern District of New York. I intend to apply for reciprocal admission to the Southern District. Again, that's where this case is being held. The fact that I have signed pleadings and letters filed in this court does not reflect any attempt by me to evade responsibility for anything. However, JayZ and his legal team, they write here in this filing that Busby, quote, has not even sought interim admission pro hoc vice while his application is pending, despite signing more filings over the ensuing weeks. Whether that reflects an improper effort to avoid the jurisdiction of this court or just a failure to act with anything approaching reasonable diligence, it reinforces the propriety of imposing sanctions here. So Spiro doubles down and tries to reassure the court that what Busby is accused of here, these Rule 11 violations he says that he has committed, that they are extreme, that this isn't levying, quote, irrelevant ad hominem attacks against Tony Busby. Now that is seemingly in reference to what I mentioned before, where the judge had chastised Alex Spiro for what he was saying about Tony Busby. They're saying it goes beyond this. This is not just personal ad hominem attacks or anything like this. And they even claim that Tony Busby is a repeat offender. So Alex Spiro writes, on October 14th, 2024, he, meaning Tony Busby, filed a different complaint on behalf of an anonymous John Doe against Mr. Combs that has also contained easily disprovable allegations. For example, that complaint asserted that John Doe had never been married, but CNN reported the contrary. He was married, and his marriage purportedly ended after the alleged assault. That is information that any attorney could obtain during an introductory meeting with his client by simply asking questions about his marital history or how the alleged assault impacted his life. The complaint also asserted that Doe was assaulted in 2006 in the Hamptons at Mr. Combs' white party. But again, CNN revealed that the white party was held in Saint-Tropez in 2006 and in the Hamptons in 2007, something Mr. Busby could have learned through a simple Google search. So let me just take a quick pause here to talk about this, because a counter-argument for Tony Busby to fight against this, I imagine, could be none of these inconsistencies in Jane Doe's account or John Doe's account make the story not true. With respect to Jane Doe, yeah, there may be details that are wrong, but isn't that natural? We're talking about something that happened 24 years ago. Well, now 25 years ago, but 24 years ago when she filed the complaint. And if the allegations are true, a victim of sexual assault could have recall issues given the trauma of that event, especially the age that she was at or allegedly at. But Spiro and JayZ kind of respond to that. They write, no corroborating data can fix the problem that virtually every event in plaintiff's narrative is contradicted by indisputable facts. And at any rate, even if there was some reason to conclude that the complaint could be salvaged, the appropriate course of action would be to voluntarily dismiss the complaint without prejudice, meaning it can be refiled again under Rule 41, while Mr. Busby determines whether the claims have a reasonable factual basis, not to leave a fundamentally defective and defamatory complaint on the docket while Mr. Busby does the work he should have done before he commenced suit. And Spiro also cites case law from this appellate court decision in support of sanctions. It's called the Levine case. And he writes, there, the court upheld sanctions where subsequent deposition testimony from both the plaintiff and one of the defendants revealed that statements in the pleadings and other filings were provably false. In so doing, the Second Circuit credited the district court's conclusions that the complaint's allegations were not well grounded in fact, and that plaintiff's counsel had ignored facts revealed through reasonable inquiry and perpetuated his misconduct through the filing of numerous memoranda well after his errors were revealed to him. That is precisely what Mr. Busby has done here. The court should come to the same conclusion as the Second Circuit in Levine. Now, this is a good argument, but at the same time, we don't know exactly what the facts were in Levine. Could be kind of different with what we're dealing with here. I'm sure when Tony Busby responds, he will address that case as well. But just going to one final thing that Alex Spiro writes in this filing. It's important because he writes, the nature of the allegations here warrants sanctions. This is not a contract dispute or a patent case. This is an allegation of child rape. To sign a pleading accusing someone of such a horrific crime without adequately vetting the allegation, particularly when the defendant's prominence means that the allegation will be repeated in headlines across the world, is deeply wrong and unethical. If lawyers do not face consequences for such a cavalier effort to destroy another person's reputation and inflict emotional harm on his loved ones, that tactic will proliferate. And at the same time, Combs has also been accused in several civil lawsuits of drugging and raping people as far back as the 90s. The allegations come from both men and women, including some who say that they were just teens when they were targeted. And in the midst of a flurry of lawsuits, before he faced criminal charges in federal court, we learned about a man named Derek Cardello Smith. This is an inmate incarcerated at Ernst C. Brooks Correctional Facility out in Michigan. Now, he has been convicted multiple times for criminal sexual conduct and kidnapping. Cardello Smith appeared on a judge's live stream from prison representing himself to explain why he wanted an injunction against, out of all people, Sean Combs.
This is in the matter of Derek Lee Cardello Smith, MDOC number 267009 versus Sean Combs, Sean Puff Daddy Combs, also known as Sean P.Diddy, also known as Diddy, Bad Boy Records, label owner, founder, also known as Puff P. Daddy, Bad Boy, Diddy Run the City, Sean Combs, also known as Sean Puffy Combs. And this is file number 24-7362NO. We'll grab your paperwork here real quick out of this other paperwork. We do have Mr. Cardello Smith appearing from the Michigan Department of Corrections. Sir, where are you currently located?
I'm located at the Ernest C. Brooks Correctional Facility, 2500 South Sheridan Drive, Muskegon, Michigan, 49444, ma'am.
All right, thank you, sir.
Or your honor.
Thank you. So I do see that we do have a proof of service on Mr. Combs. But for purposes of this hearing, you filed a motion for a temporary restraining order and or a preliminary injunction to stop all sales of the property and assets attached to or involved with said property based on the interest of plaintiff and plaintiff's connections to defendant's sexual assault of plaintiff Derek Lee Cardello Smith, requiring a preliminary injunction and or a temporary restraining order. Do you wish to argue the motion today, sir?
Yes, your honor.
All right, you may proceed then.
Okay, the purpose of it is based on two actions taken by Mr. Combs himself, directly with me here. We did a live one-on-one visit in our prison visiting room. There's two meetings within the past 2 weeks with Mr. Combs on one meeting, and then a financial advisor on the other meeting on Mr. Combs' behalf. And he stated that he would make me an offer to end the case and what happened to me because of other things that he stated he has going on in his life that require his money right now, and he wants to sell everything off. And he made me a financial offer of $2.3 million to allow what happened to me to go away. And he stated that he's going to be selling his property. And under the 2005 California Civil Code 2881-2885, the creation of liens, which allows out-of-state justices and orders to cause a stop of any title transfer, property transfers in Los Angeles or any other place that he has property. He stated that he wouldn't be able to proceed with that sale. And he did it the day after I served him the suit. And he also said that he won't be filing an answer to the complaint. He said, you can find me in default or whatever. He has a better chance with default than he would with having a restraining order stop. And I said, so you want to hide you want to hide your money and stop from being quite possibly paid to me if I'm given the benefit of a judgment in my favor for what you've done to me. And he pretty much said, yeah, he goes, you know how we get down. And I said, okay, well, I disagree with how you get down. Your sale shouldn't go through.
So I'm gonna hold on.
I'm sorry.
Cadello Smith. Okay, so you went in a different direction than I thought you were going into. I thought we were just gonna focus. No.
We are.
You kind of went off on a different direction than what your actual motion was.
Yeah.
So what I just want to say is settlement negotiations.
Yeah. I'm sorry.
In this case, are probably better not. Yeah, they're not to be placed on the record today. Okay.
I apologize.
No, it's okay. You're not an attorney. I understand that. So if we can just backtrack and focus just on your motion.
I get what you want.
Okay, thank you.
If he's allowed to sell his property that he has in LA and the properties that are in his name being used and held by other people in Michigan, then it will cause me harm because I can be tied directly to those properties through loans and through other areas of investment that I did when I was out there and while in prison through money that I've sent. And if he's allowed to go through with any of the sales, I won't be able to recoup any of my monies or anything from him as a result of any possible judgment in this action, if he's allowed to proceed with it. And an injunction or a restraining order would help ensure that he's not manipulating and selling the property to avoid his responsibility in these matters here. That's what a temporary restraining order would do. It would prevent that from happening. Because it's a very serious matter. It involves a lot of money. And him selling this would help him avoid his liability for these actions done upon me. And I was just hoping that I'd be able to get the restraining order to prevent that. There won't be any harm to him, any of the parties. There won't be any harm to him in any way. And if it's deemed that it's not justified, then he can go ahead and go through with the sale at the end of the case. But one has to be put in place to stop this from happening.
Okay. Okay. So thank you very much.
Yes.
So I received your complaint and all the attachments to it. And then I received this motion. And I just wanted to take a moment to review back through the U.S. District Civil Docket and your complaint. So I did do that. That's all. And
Yes.
Okay. Anything else?
Everything that you're looking at, they're all tied in together. Every part, as crazy as it seems, as outrageous as it seems, it all ties in. Every bit of it, every facet.
Okay. All right. Well, I have a proof of service showing that Mr. Combs was served on July 6th of 2000 and let me see, is that 24?
Yes, Your Honor.
Looks like it. 2024.
So that was August of 2024, and a month earlier in July, Combs had put his house in the Holmby Hills part of Los Angeles up for sale, and the judge agreed to issue an injunction preventing Combs from selling the property for 90 days while the rest of the case played out. And in the complaint against Combs, Cardella Smith asked for $100 million, claiming Combs drugged and raped him during a party in Detroit in 1997. He also alleges that Combs filmed the assault. And we have also learned through separate filings that Cardella Smith claims that Combs allowed him to invest in bad boy records if he took the blame for a rape case and went to prison. And get this, since Combs seemingly didn't respond to the summons, the judge issued a default judgment against him. That means $100 million was awarded to Cardella Smith. Unfortunately for him, it would not be for too long because Combs' attorneys quickly responded with emergency motions saying they had no idea that this lawsuit was even going on or who Cardella Smith was. So the default judgment was set aside and the case carries on. Now, Mark Agnifilo, who's Combs' lawyer in his federal criminal case, said this is a frivolous lawsuit against a prominent businessman based on obvious fabrications filed by a convicted rapist and serial litigant with an overactive imagination and a thirst for fame. Well, since then, Cardella Smith has been hard at work from inside prison, filing document after document after document with the court. I am talking, by the way, hundreds and hundreds of pages of arguments, case law, exhibits. In fact, he is filing so many documents in so many different courts that he seems to be having trouble keeping things like dates and locations straight. And look, in those filings, he's doing his best to, stick to the legalese and facts of the case. But remember, he is representing himself. He's not an attorney. But he ends up using a lot of underlining, all caps, exclamation points. I said it before, I'll say it again. The fact that he was initially awarded the $100 million, you got to give him credit, right? But look, he is not shy about what he has to say. For example, how about this quote from his proposed 250-page answer to the defendant's motion to dismiss? Defendant Sean Combs is a fake gangster hiding behind his money and his lawyers, and most importantly, his enforcers, who knows that he has committed multiple acts of fraud, and it has been an ongoing thing. His fraud is eternal, and his entire empire was built on rape, torture, being a fake gangster, rapist, brutal, power-hungry, greedy millionaire, and quite simply, he is not a man. Wow. And remember, Combs says he doesn't even know who Cardella Smith is. And we have to be clear about something. Sean Combs has never been criminally charged for rape or sexual assault per se. And as far as the federal charges, he hasn't been found guilty. And for all the lawsuits, he hasn't been found liable in any of them as well. Now, he has entered a not guilty plea in federal court. He strongly denies any of these allegations. But who is this Derek Cardella Smith character, right? And how, by the way, does Jennifer Lopez fit into all of this? Well, according to the Michigan Department of Corrections, Cardella Smith is serving a decades-long prison sentence at a correctional facility near Muskegon. In 1998, Cardella Smith was convicted of 2 counts of third-degree sexual conduct. He was paroled, and while out, prosecutors say he committed more sexual offenses. He was convicted in 2008 on 6 counts of first-degree criminal sexual conduct and 2 counts of kidnapping, pled no contest in that case. And then in 2019, he was convicted of 4 counts of first-degree criminal sexual conduct. And according to the Department of Corrections, the earliest release date for him is 2036. So Cardella Smith, by the way, has appealed all of those convictions over the years and says that he was falsely accused of rape in 1998, that he was set up by police. And by the way, in his filing against Combs, Cardella Smith also claims that there is collusion, that there is a conspiracy afoot, saying and alleging that Detroit police covered up his rape at Combs' instruction. And that is not even the wildest claim in this lawsuit, so let's dig into it. November 9th, Cardella Smith filed a notice of submission of material witnesses and named 3 people: New York police officer Derek Palmer, former Combs employee Kirk Burrows, and pop superstar Jennifer Lopez, J-Lo, who dated Combs from 1999 to 2001. And possibly one of the most memorable headline-making moments of the relationship came in December of 1999 when Combs, Lopez, Combs' bodyguard Anthony Wolf Jones, and rapper Jamal Shine Barrow were involved in an argument at a New York City nightclub that led to gunshots. All 4 were arrested on charges after they left the club in a car. Police pulled them over after they ran a red light. A gun was found lying in the car in full view, according to police reports. And the weapon, turns out, had been reported stolen out in Georgia, and none of the people in the car had a license for the gun. Now, the charges against Lopez, they were dropped, And after a trial in New York, Combs and his bodyguard were acquitted. Shine, though, was found guilty of criminal possession of a weapon and first-degree assault. He was acquitted on the charge of attempted murder, and he served nearly 9 years for his charges. He since said that Combs was the one who actually fired the shots, and he took the fall for him. Going back to Cardella Smith's filing, his notice says that Jennifer Lynn Lopez, a.k.a. J-Lo, a.k.a. Jenny from the Block, quote, will be called as a material witness and expert to Sean Combs' viewing, possession, and distribution of his sexual assault upon the plaintiff in 1997 and the orders of defendant Sean Combs forcing Jennifer Lopez to remain silent about the videotaped sexual assault of plaintiff by defendant. Plaintiff states that the material witness Jennifer Lynn Lopez, also known as J-Lo and Jenny from the Block, was engaged in a relationship with the defendant Sean Combs during 1999 and 2001, and that the sexual assault of the plaintiff was recorded, distributed, and held by the defendant at his New York residence and recording studio. And during the relationship with Jennifer Lopez, she was made privy to this video that was taken by Sean Combs and his employee Kirk Burrows. She, J-Lo, has known this video existed and was in existence and took no action to make it known to anyone in law enforcement, and that she was even questioned by New York Police Detective Derek Palmer about this matter, and that the report will show that her answers to this tape was and still remains a resounding yes to its existence. And again, Cardella Smith writes that he wants to call Officer Derek Palmer as a witness because he says Palmer is the one who questioned Lopez and believes that he will have testimony that could help his case. Now, as I mentioned, Diddy's legal team has called for this entire case to be thrown out. Cardella Smith has filed a massive response to that request that totaled more than 200 pages. Probably half of it was just straight up copies of case law that seems to support his arguments, word for word. It's something out of like a legal textbook. There's so much to slog through, but I kind of want to give you some of the highlights. So first, in addition to the claims of rape and a cover-up, Cardella Smith also claims and alleges that Combs was violent towards his loved ones. At times, Cardella Smith addresses alleged threats against his family. Other times, he says Combs actually caused serious injuries to his brother. Reads, defendant used threats of murder to force the plaintiff to not bring the case to any court of law enforcement until the homes of the defendant were raided by Homeland Security, that the plaintiff knew it was a safe time to bring the case, and that is why we are here at this juncture. And Cardella Smith argued that fear for his own safety and the safety of his family is one of the main reasons that he waited so long to report the alleged rape, and says that that reason alone should override any issue with the statute of limitations, that these claims might otherwise be time barred. And he also argues that while he's been in prison, fellow inmates and prison guards have threatened him on behalf of Sean Combs. Plaintiff states that the court cannot authorize the dismissal of these claims because to do so would mean that the plaintiff was time barred because the plaintiff did not want to take any action that could have resulted in the death or danger of his family, friends, or their family by filing this report until after Homeland Security got involved. And if this court does not grant dismissal of this claim, then it would be instructing the defendants of a sexual assault claim brought by a plaintiff to threaten to kill the victim's family members, and then they would be able to get away with it. And that is most certainly this court authorizing murder. Wow. And when it came to threats, by the way, Cardella Smith swears that Combs visited him in prison on August 28th, 2024. Though that is just days before his arrest on September 16th. In fact, he claims that Combs visited him multiple times in prison and that the visitor logs and the security video will prove it. But he also claims that that evidence is being buried. According to Cardella Smith, Combs threatened him on that day in August, saying, quote, "What up, N-word? So I see you have been getting my messages and your family has too. That is good, and they can keep it that way by staying quiet. I am untouchable, N-word." And Cardella Smith even went so far as to accuse some of Combs' attorneys of helping him cover up these crimes. He says he believes attorneys from the law office of Fink Bressak and Sher Tremonte should have their licenses reviewed for possible disbarment. It is terrible because they are hiding behind their law licenses to do these deplorable acts, and one can only say that for them to defend a rapist, thief, fraud, manipulator, extortionist, sadist, fake gangster such as Sean Combs and get a paycheck for it and do it with a straight face and then sleep at night, well, it makes them just as worse as their client, and it is deplorable. And I reject every single word they have said and every statement they have made in their motion to dismiss because they are liars and just wrong and misusing the laws to lie to this court and help Mr. Sean Combs get away with his rape. Attorneys on behalf of Sean Combs have filed multiple documents that call Cardella Smith's assertions transparently false, stating in a filing once again, plaintiff seeks to persuade this court that he is the subject of an ever-growing conspiracy to frame him and cover up an alleged assault. The lawyers allege that affidavits, transcripts, other exhibits reportedly from people with connections to Combs are just fake documents. For example, one of the documents names Catherine Preston as defendant's agent, but according to Combs' attorneys, Catherine Preston is an intimate associate of plaintiff, whom plaintiff refers to as his wife. They also point out that, quote, the additions to the proposed response are elaborations on plaintiff's conspiratorial narrative, including the claim that defendant, again Sean Combs, must have had plaintiff's mother killed because the coroner listed her cause of death as undetermined. And they end by saying that even if every single claim that Cardella Smith was making in his amended response was true, his claim is time-barred by the statute of limitations, and therefore all of this is moot. Now, so far, no word from the judge on whether Cardella Smith's amended response will be accepted by the court or not, but should be interesting to see. And in the meantime, Combs' legal team is also asking the court to sanction Cardella Smith for his frivolous lawsuits, or for what they claim are frivolous lawsuits, and they want to keep him from filing any more of them. They state this is not plaintiff's first attempt at a shakedown, and unless this court intervenes, it will not be his last. Plaintiff has a lengthy history of filing frivolous lawsuits in this district and beyond. A PACER search reveals that plaintiff appears on the caption in 173 lawsuits and appeals in the Sixth Circuit and its district courts. The overwhelming majority, if not all, of plaintiff's cases have been dismissed as meritless. Still, he has continued filing. Numerous judges have admonished plaintiff to stop litigating. Plaintiff has ignored them. But we shall see if this is another case that gets thrown out, or maybe it will progress. Time will tell. That's all we have for you right now.